is Suzanne Vasquez. I'm an immigration attorney in Orlando, Florida, and I've been practicing in the area of immigration for 20 years. I am board certified by the Florida Bar, and I'm here today to talk to you about H1B visas. So the H1B is a non-immigrant temporary work visa. It's a highly specialized visa. It requires a professional position that's a specialty occupation. The specialty occupation has to match the foreign national's degree or be very close to it. If the foreign national's degree doesn't match up exactly, we can also look at work experience to see if we can combine the work experience with the degree to arrive at the equivalency needed to show the specialty occupation. Examples of specialty occupations are accountant, engineer, software engineer, computer science, any field that you can think of where you needed to go to college and at least obtain a bachelor's degree in order to practice the field would probably qualify for an H1B. So the H1B visa does have fees that have to be paid to the government. And those fees range depending on the number of employees and also whether the employer is H1B dependent or not. But generally speaking, your employer would be paying at least $2,500 to the government to sponsor you, as well as fees to an attorney. That could also range just depending on the complexity of your case, how many dependents there are involved, and whether you receive a request for evidence and how an attorney charges for that. The employer really should pay all the fees to the government. There is, the Department of Labor that's involved with the H-1B, and there's U.S. worker protections built into this visa. So there's a prevailing wage that's required, and there's certain attestations that the employer must make to the government to ensure the government that jobs are not being taken away from U.S. workers in order to hire foreign workers at lower rates of pay. So because it's a specialty occupation visa, it requires that the foreign national have a degree that matches the specialty occupation or progressively experience in that area of the profession. So a comparable number of years to a degree. So generally speaking, 3 years equals 1 year of a bachelor's degree. So if you didn't have a bachelor's degree, let's say you had an associate's, we would take your associate's degree and combine it with your experience to send to a credential evaluation company to see if we could get you the equivalency of a bachelor's degree. But you must have at least a bachelor's degree or its equivalent, and it must match the job that's being offered to you, which must be considered a specialty occupation. That is the main requirement for the H-1B visa. So you can bring your spouse and children with you if you have an H-1B petition that's been approved. Your spouse and children would be on H-4 visa or H-4 status. The spouse is not automatically entitled to work authorization, but if you're from a country where you're going to be waiting a long time for your immigrant visa, once an I-140 petition is approved for you, then your spouse can apply for work authorization, but that would be down the road. Your children are considered dependents until the age of 21, and they can attend public school and college until that age. So the H-1B has a 6-year limit. It's issued up to 3 years each time you apply. And if your employer starts the green card process for you by your 5th year, then you should be able to get extensions beyond the 6 years while that green card process is ongoing. So when an employer applies for an H-1B, they send the application to USCIS in the United States. And if it's approved, there's an approved petition. If you're in the United States and you're eligible for a change of status, you may be approved as a change of status. If you're not in the United States, it may be approved as a petition and you would have to travel abroad, or if you were already abroad, present yourself at your consulate for the visas to be issued in your passport. If you're already here, say you're a student on OPT, you could possibly do a change of status and never have to go get a visa unless, of course, you wanted to travel internationally. So the H-1B visa is numerically limited, so there's only a certain number of visas that are issued each fiscal year. So you'll often hear people talk about H1B season. So registration opens up in March, and the employer needs to start the process for you no later than February to really get everything in order and do the due diligence to make sure that you match up with the job that's being offered and that the business is going to be recognized by the Department of Labor for LCA purposes, and have enough leeway so that if anything goes wrong or there are any glitches with computers, etc., that you've not waited until the last minute. But generally speaking, there's a registration process, and then by the end of March, we should know whether you've been selected in the lottery or not. There's a regular cap and a master's cap. You have to have graduated from a U.S. Accredited institution in order to be counted in the U.S. master's cap. The benefit to that is there's additional visas available if you've graduated with the U.S. master's. And depending on which cap you get selected in, you will get a notice on the registration that tells your employer where the application needs to be filed. You will also be instructed, or your employer will be instructed, as to when the application must be filed. So generally speaking, it must be filed within 3 months after the registration period. And then if, depending on the amount of applications USCIS receives after that deadline, they may open up more visas. So they will go back in and do another sweep of the registrations to where even if you weren't initially selected in a registration, you could later be selected for that same fiscal year. But generally speaking, if you weren't selected in that fiscal year registration, then you could try again the following year. So the H1B visa always, if it's subject to the cap, is always going to have an October 1st start date. So if your employer applies for you in April or May, even if it was approved within a month or two, you still wouldn't be able to work in H1B status until October 1st of that year. So some years premium processing is available or may become available sometime before the end of September. And so you could know sooner than you're actually eligible to start working on your H1B. So the answer to that question is, how long does it take? Well, it depends. But generally speaking, you'll be applying sometime between April and September, and you should know within a few months, especially if you're able to use premium processing. Yes, so the typical route for an H1B who wants to remain permanently is through labor certification, where the employer who sponsors you for the H1B does a test of the labor market to see if there's any U.S. workers qualified for the position. And if there's not, during the period of time that they're conducting the recruitment, then the employer can submit labor certification for you to the Department of Labor. And if it's certified, then you and your family, your spouse and dependents under 21 years of age, can obtain permanent residency in the United States. Well, I know you have lots of choices when it comes to immigration attorneys, but we would hope that you would look at our backgrounds and our experience and find us qualified. We are very responsive to our clients' needs, and we really do value every client. We understand that you're putting your future and your family's future in our hands, and we take that very seriously. We do have a lot of experience with all types of immigration visas, including H1B and labor certification. And we stay on top of all of the latest developments in the law. With the H1B, for example, there's different trends that come year to year, really, on requests for evidence. And is a certain specialty occupation going to be challenged? And if so, how are we going to deal with those challenges? And we are prepared to do that. We stay on top of all of the latest developments, including developments of legal arguments based on court cases, as well as the USCIS's own guidance and policies, which sometimes they ignore, and then we remind them.